Greetings, my name is Erick Kaardal. I'm the attorney in the Save Mille Lacs Sportfishing lawsuit, and this is an update to where we're at in that lawsuit. Today is July 23rd, 2014. We have now proceeded in the Court of Appeals challenging the validity of the rule. If you recall, the appeal to the Minnesota Court of Appeals was challenging the fishing rules adopted by the Department of Natural Resources in 2014 and previously. Our principal argument is that the Minnesota Department of Natural Resources has failed in its administrative process to apply the 1998 constitutional amendment requiring the Department of Natural Resources to preserve hunting and fishing heritage in Minnesota statewide. Why is that important? Well, in 1998, the Minnesota people voted to amend the Minnesota Constitution to preserve hunting and fishing heritage. Now, there's no question that this amendment was intended and directed at the Minnesota Department of Natural Resources. What other agency would it be directed at? So there's only one agency the people of Minnesota was sending this message to, and that was the Minnesota Department of Natural Resources. The Minnesota Department of Natural Resources adopts all the hunting and fishing rules statewide. And so here we have a situation for the last 15 years. The Minnesota Department of Natural Resources has been adopting hunting and fishing rules without reference to the people's law. Is it important? Absolutely. The very first consideration that the Minnesota Department of Natural Resources should consider when adopting any hunting and fishing rule affecting the people of Minnesota is this amendment preserving the people's hunting and fishing heritage. It should always be on their mind. It should be on their mind when they start the rulemaking process. It should be on their mind in the middle of the rulemaking process, and most importantly, it should be in their mind when they adopt the hunting and fishing rules at the end of the administrative process. So in our appeal, we filed our appeal challenging the validity of the rule based on a failure to consider and apply for this amendment. We did not have the administrative record when we filed the appeal, but we filed the appeal on a suspicion that they had not applied the law. Well, after we filed the appeal as required by law, the Minnesota Department of Natural Resources produced through the Assistant Attorney General the record. The administrative record was 18,700 pages. We received these 18,700 pages, and one by one, we flipped over the pages. 1, 2, 3, 4, 5, all the way to 18,700. And you know what we didn't find? We didn't find one reference to the Minnesota Constitutional Amendment preserving hunting and fishing heritage. How can the Minnesota Department of Natural Resources, which makes claims of expertise in every subject area that it deals with, miss the applicable law in all the hunting and fishing rule administrative processes it's had since 1998? It's an unbelievable error. Now, one would say, well, why won't the court let the agency off the hook? Well, there's very good case law that one of the ways that the agency can make a mistake is by, in its administrative process, here we have 18,700 pages, is not referring to the applicable law. And an agency cannot, after it's completed its administrative process and adopted a rule, can't come into court and say, oh no, we considered it even though we didn't mention it. Well, it's impossible for them to show, after 18,700 pages of consideration, if they don't even reference the law, that they actually considered and applied it. That would be an outrageous claim. So what have they left as we wait for their response? What do they have left? Well, what they should do is they just admit that they made a mistake. Now, it's a colossal error. I mean, it's one thing to miss little laws. It's one thing to miss, bigger laws. But this is the biggest law, the Constitution of Minnesota. The people of Minnesota went through the expense of voting on it and voted for it overwhelmingly, and it was a direction to one state agency, only one, the Department of Natural Resources. And how could they miss it? How can they be so disrespectful to people and the people's laws to miss this on such an important project as adopting the fishing rules for Mille Lacs Lake? And we know what the consequences are. This is a tragedy of the commons, not caused by fishermen who have zealously overfished and not left enough fish to spawn. No, there have been intense administrative resources thrown at this problem, And the result of the DNR's actions with respect to Mille Lacs and fishing rules has been the walleye population has been decimated. So this is the tragedy of the commons caused by the government. And the government has caused this problem because it hasn't applied the law. If the government, the Department of Natural Resources, had applied the law, they would have remembered that for 100 or more years, Mille Lacs Lake has been a walleye lake. It's a walleye lake. That's the fishing heritage. There are dozens of books and memoirs and family history books written about Mille Lacs and walleye fishing. It's part of our Minnesota heritage. No one can dispute that, except the DNR has tried to dispute that by telling resort owners, well, you got to learn how to market smallmouth bass fishing, you know, learn how to market northern pike fishing. But no, wait, if they knew the law knew of the law that said they're required, that is, the DNR is required to preserve that walleye heritage at Mille Lacs Lake, then they couldn't say those things. So when they're getting together in the little groups, they would be saying, we got to save walleye fishing on Mille Lacs. We got to save walleye fishing on Mille Lacs. But instead, all these other political considerations have come in, and that's just wrong. So when we look at the appeal process, we're waiting for the response brief from the Department of Natural Resources through the Assistant Attorney General. We're going to get that next week. And then we'll be evaluating that. If the Department of Natural Resources doesn't have an argument, which I don't think they do, that they applied the constitutional amendment, we probably won't even reply. Why would we? I mean, if we don't have a response, they're just trying to distract the court from what the issue is. And then we'll proceed to oral argument, and then the Court of Appeals will have 90 days to decide whether this is a violation of the law and whether the rule is invalid. And if the rule is found invalid, then it's a complete reset on Mille Lacs Lake fishing rules. Everything has to be redone. Everything since '98, everything since the treaty case was resolved. And that's a good thing. Now, why is it good? Because this is a government-caused problem. The Department of Natural Resources did it to the people, not only the sports fishermen, but also the American Indian tribe there. And with respect to the American Indian tribe, this is an instance where the people, the sports fishermen, and the American Indians agree. I mean, it's a disaster for everyone that the walleye fishing population has been destroyed and there isn't any tourism in that regard anymore. It's decimated. It's a disaster for sports fishermen, disaster for the American Indian tribe, but the other point of agreement between the American Indian tribe and the sports fishermen is there's only one responsible party. That's the Department of Natural Resources has made colossal errors and colossal mistakes. And here, the colossal error isn't something that gets lost in the science, gets lost in the mathematics of fish populations or predator-prey relationships. No, the mistake is the Department of Natural Resources failed to apply the People's Law, the constitutional amendment to preserve hunting and fishing heritage as it related to the Mille Lacs Lake walleye population. I am proud to represent sports fishermen and the resort owners in this case because they are so right to address this tragedy of the commons, and the principal beneficiary will be the public. Thank you.